Welcome to the Deep Dive. We take your curiosity, dig into some fascinating sources, and we'll pull out the key insights for you. Today, we're embarking on a pretty crucial journey, looking into something absolutely fundamental: human rights. Our deep dive is specifically looking at the legal side of things in Pakistan, mainly through a paper by Dr. Fakir Hussain. He's the Director General of the Center of Excellence for Law and Judicial Education. We're going to explore, the essence of human rights, how they're protected, and really focus on the role of the judiciary, especially when it comes to safeguarding women's rights.
Exactly. Our mission today is really to unpack not just what human rights are, but why they're so foundational, for social stability, and how the legal system, especially down at the local district level, really acts as that frontline defense for these dignities we all inherently have. We'll explore that sort of intricate dance between big international agreements, the national constitution, and just the day-to-day work of delivering justice right down at the grassroots level.
Okay, so let's dive in. We'll explore what makes life, well, worth living from a rights point of view, the sometimes surprising consequences when those rights get denied, and then we'll zoom right in on how specific legal frameworks and judicial actions in Pakistan are trying to create a more just society, particularly for women. You might actually be surprised at some of the creative ways courts interpret and enforce these really critical protections. Okay, so our sources start off by linking human rights intrinsically to fundamental rights. What's the core idea the paper wants us to get about these rights?
Well, the paper really hammers home that these aren't just, nice ideas floating around. They are legally binding. They're enforceable rights, privileges, freedoms. And crucially, they apply to everyone. No distinction, no discrimination. Doesn't matter about nationality, where you're from, caste, creed, color, or gender. They're seen as so inherent, so basic, that without them, you really can't have proper human development or societal progress. It's just, inconceivable according to the source.
Right. It paints this picture of a life worth living, and that assumes certain protections are in place. Safety, dignity, property, liberty, equality, freedom of thought, belief, expression.
All the essentials. Movement, association, too.
Exactly. But here's a really crucial insight the paper stresses. Denying these rights, it's not just a personal tragedy for the individual involved. It's actually a precursor to wider conflict.
Absolutely. The source makes a really compelling case that when states fail to observe even minimum standards of civilized behavior, leading to human rights violations, that becomes a major cause of international strife, of tension. Historically, you can link it to things like domination, colonization, economic exploitation, and it always results in profound loss and suffering.
So this isn't just about, big international wars then. The paper draws a direct line. What's true globally?
It's equally true, the paper says, of domestic unrest and tensions in nations that deny rights to their own citizens.
And those states, the paper argues, they tend to remain weak, underdeveloped, vulnerable even. Why? Because of brutal treatment and a lack of access to justice, a way to fix grievances.
Which leads us to a really interesting question. How did this powerful idea of human rights actually become a global movement? The source describes it as a new and evolving concept. As civilization advanced, nations started focusing more on tackling the root causes of these recurring crises. And that kind of ignited this focused human rights movement, which led to some major international legal instruments.
Right, and that movement really kicked off with the UN Charter. It championed fundamental human rights, the dignity and worth of the human person, and importantly, the equal rights of men and women. But the absolute peak, the real game changer, was the Universal Declaration of Human Rights in 1948, adopted unanimously. Huge. It guaranteed all those essential rights: civil, economic, social, political. And it became this global yardstick, didn't it, for measuring how countries treat human rights. And that amazing step didn't stop there. It sparked a whole wave of treaties, like the International Covenants in '66 and then CEDAW in '79. Okay, so building on that incredible foundation, our deep dive really focuses in now on protecting women's rights. The adoption of the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, in 1979, it's described as a milestone.
Oh, absolutely. It was a truly crucial step forward. CEDAW basically packaged up international standards for protecting women's rights, for enhancing their status, making sure they were integrated as equal partners in progress and development. The convention itself was, in a way, the global community saying, look, the state of affairs for women worldwide is pretty dismal, and it showed a powerful determination to end abuse, exploitation, injustice, and discrimination against women.
And what's particularly innovative or maybe unique about CEDAW is how it defines discrimination against women in Article 1.
Yes, it's described as both novel and unique. Novel, because it moved past earlier, maybe vaguer phrases like discrimination on the basis of sex. It made it much clearer, more specific just by using discrimination against women. Very direct. And unique because it's incredibly comprehensive. It covers, well, pretty much all acts and aspects of discrimination. Intentional, unintentional, direct, indirect.
Doesn't matter if it's by public institutions or private companies.
Exactly. Or even discriminatory practices happening within the family, in the domestic sphere. It really aims to leave no stone unturned.
And beyond CEDAW, the source points to a whole wave of other international agreements specifically for women. Things like political rights, nationality for married women, consent to marriage.
Yeah, conventions from the 50s and 60s, plus efforts by agencies like the ILO, UNICEF, UNESCO.
It really paints a picture of a consistent, decades-long global push to improve women's status across the board: civil, social, economic, political. Now, our sources tackle something that comes up in many cultures.
Yeah.
How do deeply rooted traditions or certain religious interpretations align with these universal human rights ideas? The paper looks at this directly, particularly regarding Islamic injunctions within the context of Pakistan.
And this is a really vital point to clarify. The paper strongly argues that any claims of discriminatory provisions in law books based on, quote, misconceived religious notions and orthodox norms are actually contradicted by the true spirit of Islam. It states quite unequivocally that Islam is the most enlightened religion and cannot sanction gender discrimination. In fact, it emphasizes that a lot of Islamic philosophy is actually dedicated to female emancipation and equality.
Right. And the paper brings up specific quotes from the Quran to back this up, like, women shall have rights similar to the rights against them according to what is equitable. That's from 2.228. And another one, there shall be no distinction among men and women in the area of moral and spiritual rights and obligations. That's XD 3.35.
Yeah, and if you connect that to the bigger picture, the paper highlights how Islam grants women equality with men in civil, political, social, economic rights. The Quran itself strongly asserts the need to protect human rights, especially for the weak and vulnerable. And the source even notes the Holy Prophet's farewell pilgrimage sermon as providing a concrete foundation for human rights, including equality and banning discrimination.
So the issue, according to this paper at least, isn't the religion itself. It's how it gets interpreted sometimes. It mentions that conservative elements interpret the religious injunctions retrogressively, which creates, avoidable controversies and problems. And that just underscores the need for strengthening liberal education, including religious instruction itself. Okay, moving from those international and religious principles, the source then looks at how Pakistan's own constitution lines up with these ideals.
Right. And that principle of non-discrimination, which is so central to CEDAW, it's actually deeply embedded in Pakistan's constitution. The preamble itself commits the state to ensuring democracy, freedom, equality, tolerance, social justice, and guaranteeing fundamental rights, including equality of status, opportunity, and importantly, equality before the law.
And it gets pretty specific, too. Article 3, for example, mandates the state to eliminate all forms of exploitation explicitly, including that of women. Article 4 guarantees the fundamental right to protection of law, which is basically enshrining the rule of law. Then you have Articles 25, 26, and 27 laying out specific non-discrimination principles: equality before the law, equal access to public places, and non-discrimination in public service appointments based on sex.
And the Constitution doesn't stop there. It has specific protective provisions for women. Article 37E obliges the state to ensure just and humane working conditions, provide maternity benefits, and ensure women aren't employed in jobs unsuited to their sex. Article 35 commands protection for marriage, family, mother, and child. Article 34 directs the state to help women participate fully in all spheres of national life. And crucially, it explicitly allows for positive measures of affirmative action to boost women's status. Plus, it guarantees representation through reserved seats in local government and the legislature.
So we've talked about these really powerful ideals, these strong frameworks on paper, but the paper is also realistic. It acknowledges a stark reality, saying, quote, "It would not be fair to give the impression that all legislative measures and policy guidelines are fully and effectively implemented. Unfortunately, this is not the case."
Which naturally raises the question, why the gap? What causes this difference between the law on the books and the reality on the ground? The source points to a few things. 1, there might still be some discriminatory provisions lingering in the statutes. 2, there are real problems actually implementing beneficial laws like those related to inheritance. 3, you have these pervasive sociocultural norms that often work against women's rights. And 4, sometimes it's just down to inadequate resources hindering full enforcement.
And this is precisely where the judiciary is meant to step in, right?
Exactly. The Constitution gives the judiciary the mandate to safeguard, protect, and enforce these fundamental and legal rights. And importantly, both the preamble and Article 175 guarantee its independence from the executive branch. That independence is reinforced by landmark Supreme Court judgments and protected through things like qualifications for judges, how they're appointed, security of tenure, and so on.
And access to justice itself is seen as a fundamental right.
Yes, established by Supreme Court judgments. The state has a duty to provide effective ways for people to access justice. And the judiciary, while it has different levels, is conceptually seen as one unified system, all parts working towards that common goal: free, fair, impartial justice for everyone.
Now, when we think of justice, often our minds jump straight to the Supreme Court, the highest levels. But our source makes it really clear. The district judiciary, the local courts, they are a crucial organ. They're the real front line.
Yeah, and there's some fascinating data here. Only about 10% of cases actually end up in the superior courts. A huge 90% of litigation is pending in these subordinate or district courts. So that means for most citizens, their first and often only interaction with the justice system is at this local level. This is where the benefits of the law must reach the common person. Their importance, just in terms of public contact and sheer volume of cases, is massive.
So what does that mean for you, the listener? It means these local courts, whether labeled superior or subordinate, they have a binding obligation. They must decide cases according to the law, ensuring all those constitutional safeguards, rule of law, fair trial, due process, equality, protection from torture. They have a really solemn duty to prevent what the paper calls brazen violations, things like extrajudicial killings, deaths in custody, arbitrary arrests.
And crucially, the district judiciary has an active role to protect the rights and interests of the weaker, more vulnerable sections of society. That includes women, children, prisoners, minorities, other disadvantaged groups. Recent legal changes, like the amendment to Section 491 of the Criminal Procedure Code, even gives senior district judges the power to issue writs of habeas corpus. That broadens their power to step in and enforce fundamental and legal rights directly. They also play a key role in speeding up cases and keeping costs down.
Okay, our sources then get into some very specific laws and amendments in Pakistan designed to protect women. And this next point really caught my eye. In murder cases, there was a 2005 amendment to Section 302 of the Pakistan Penal Code. It specifically ensured that for honor killings, the lesser punishment option, imprisonment up to 25 years, is not available. The punishment remains death or life imprisonment. It really emphasizes the severity of those specific crimes.
Right, which prompts the question, what other specific legal tools are highlighted for protecting women? Well, the source points to other critical amendments. Section 305 clarifies something important about wali, the legal guardian or heir. In an honor killing case, the accused or convict cannot be the wali who could traditionally waive or compound qisas, which is the Islamic principle of retribution or retaliation. And Section 310 directly prohibits giving a woman or girl in marriage as badalisul, basically, as compensation for a crime like murder, to settle a feud. Section 310A makes doing that an offense itself punishable by up to 10 years. These close off potential loopholes that could be misused.
And beyond those really serious crimes, there are protections against, say, insulting modesty or sexual harassment.
Yes, Section 509 of the PPC covers that, with penalties up to 3 years in prison and a significant fine. Plus, there's the specific protection against harassment of women at the Workplace Act from 2010. That sets up a whole framework for dealing with workplace harassment, including internal inquiries and appeals to an ombudsman.
What about family disputes?
There was an amendment in 2002 to the Family Court Act. It gave family judges the powers of a magistrate for certain offenses involving spouses, like causing hurt or wrongful restraint. The idea was to create a more suitable environment within the family court system itself to encourage conciliation and resolve these issues efficiently. Other key laws mentioned are the Muslim Family Laws Ordinance 1961 that covers marriage registration, acknowledges delegated divorce rights for wives, and requires a husband to get permission for a second marriage. The Family Court Act 1964 aims for speedy resolution of disputes over divorce, dower, maintenance, child custody. And even the old Child Marriage Restraint Act from 1929 has been strengthened, particularly by the Sindh Child Marriage Restraint Act 2013. That sets a uniform marriage age of 18 and imposes pretty hefty penalties for arranging or conducting child marriages.
It's really striking how the legal system is also evolving to protect women's economic rights, specifically inheritance.
Absolutely. The Muslim personal law, Sharia Application Act of 1962 is meant to ensure women get their rightful inheritance shares according to Islamic law.
Hmm.
And more recently, amendments to the PPC sections 498A, B, and C have made it a serious criminal offense to deprive women of inheritance through deceit or illegal means, or to force them into marriage through coercion, or even compel marriage with the Holy Quran, which has been a harmful practice. These now carry significant penalties.
So looking ahead, what does this all mean for the future? The paper offers some reformative measures, a vision for the way forward. A key part seems to be expanding the scope of human rights and, crucially, implementing them effectively.
Indeed. Now, Pakistan technically follows dualism, meaning international treaties usually need a specific domestic law to be directly applied by courts. But the superior courts have shown a willingness to be quite liberal and progressive in their interpretations. Cases like Sheila Zia v. Wapdi saw the court applying norms from UN declarations, even though they weren't formally binding domestic law. In another case, Wajid Shamasul Hassan actually struck down a part of a domestic law because it conflicted with principles in the UDHR and ICCPR. It emphasized that these internationally recognized rights are important, even if Pakistan hadn't ratified those specific treaties. Mere non-ratification doesn't make them irrelevant.
That really shows the judiciary actively bridging the gap between national law and global human rights standards, doesn't it? Beyond this, the paper strongly calls for the full implementation of laws that specifically benefit women, especially those enhancing their status.
Right, which leads us to wonder, how can that be done more effectively? Especially thinking about affirmative action and inheritance rights. Well, the source points back to Article 25 of the Constitution, which allows for affirmative action. It cites the Shirin Munir case, where a quota for girls in medical college admissions was upheld as a perfectly permissible measure to address past imbalances. And on property, cases like Inaya Bibi ensured Christian women could inherit property, going against customary law that denied them that right. Another important one, Ghulam Ali, rejected claims by brothers trying to take over ancestral property rightfully belonging to their sisters through adverse possession. These judgments really show the courts stepping in to correct historical injustices related to property and inheritance.
And the paper gets quite concrete with proposals for inheritance reform, doesn't it?
Yes, very practical suggestions, like making it mandatory for revenue and taxation authorities to automatically update property records to include all legal heirs when someone passes away, no need for heirs to initiate sometimes complex proceedings, also requiring compulsory registration when inheritance rights are transferred, and even empowering civil courts to take notice of inheritance disputes on their own initiative, suo motu cognizance. Then these courts could use arbitration or mediation to find amicable solutions, or if not, decide the case quickly, maybe within 3 months.
And there's already a push for faster handling of cases involving women and children.
Yes, the National Judicial Policy from 2009 specifically prioritized those cases for early disposal. And the judiciary itself recognizes the need to continue reforming and modernizing its processes. Because an effective, efficient judicial system that actively protects fundamental rights, it has a direct positive impact on peace, on law and order, sure, but also, crucially, on trade, commerce, economic development. International investors definitely look for that kind of stable, reliable legal system. It's key for confidence.
The paper wraps up by stating that developed nations thrive on the supremacy of law and impartial justice. Respect for human rights is called a sine qua non, an absolutely essential condition for good governance and socioeconomic development. And the law is increasingly seen as an instrument of change. The judiciary, the paper concludes, is naturally expected to play its vital role in laying that sound foundation for progress. So what does this all mean for you, our listener? We've really delved into the deep meaning of human rights, seen how denying them can fuel conflict, and we've explored this complex journey of protecting them from big international declarations down to national constitutions, with a real spotlight on the crucial role of the judiciary in Pakistan, particularly for women. The path clearly isn't always smooth, implementation gaps exist, but that commitment to justice, especially coming from the district judiciary on the front lines, is presented as a really powerful force for progress and development.
Yeah, and if you connect all this to the bigger picture, it's clear the judiciary isn't just seen as an interpreter of laws. It's positioned as an active guardian of our fundamental dignities. It shapes society's ability to achieve peace, equity, good governance, and economic growth. And that, in turn, sustains the confidence of everyone, citizens and international investors alike.
Okay, so here's a final, perhaps provocative thought for you to carry forward from our dive today. If the way local district courts enforce these laws has such a profound impact on national development and even international confidence, What more could be done, realistically, to empower these frontline courts, to ensure that justice truly, effectively reaches every single person in society?
We certainly hope this deep dive has given you some valuable insights today and maybe sparked some further curiosity on the topic.
Thank you for joining us on the deep dive. Until next time, keep exploring, keep questioning, and keep being well informed.